start back. The next issue I mentioned that I wanted to talk about was employment. It was some clarification points more than anything, really. More specifically in terms of the impact that the proposal could have on the local labour market profile. In the appellant's evidence, that indicates that around 9.5% of nearby workforce is employed in construction industries, and it's down to therefore the likelihood of the scheme being able to contribute towards that workforce. So how would that be commuted with the proposal in terms of local employment and skills provision, for example? How would you ensure that that's secured through the scheme?
Because so there's no formal mechanism in the 106 obligation, as you sometimes see in other parts of the country, where once again they have more up-to-date local plans with policies, and then they have SPDs that hang off those policies. We are not in that position here because of the plan making history here in Castle Point. But nevertheless, the thrust of our evidence is to demonstrate that in this particular area there is a high proportion of people in the industry, in the construction industry, and that this both in terms of construction but also in the maintenance. It's not we tend to focus on construction, but in terms of the long-term maintenance of this, it would contribute to the provision of employment locally. That's really our point.
Any comments from the council on that particular point?
No, not really, sir. I mean, it is what it is. We accept the fact there will be employment generated. Where it will go or who will benefit from it is a bit crystal ball gazing, to be perfectly honest.
Okay, thank you. Okay, so that was the only question about specifically about employment that I had myself, but it then goes to you from the appellant's perspective, if there's anything that you would like to identify or expand upon regarding the other benefits that you've referred to in your evidence base, including any weight that you might want to afford to, for example, economic, social or environmental benefits.
Yeah, thank you, sir. I mean, sorry, just to clarify, obviously there's those benefits listed in the Statement of Common Ground, one of which is the residual social and economic benefits. Obviously, separate to that is the environmental performance of the dwellings. I don't know if your question was covering all of that.
Yes, well, so if you want to touch on everything, basically everything else that I may have not referred to already.
No, understood, thank you, sir. So I think points where we're at odds with on the council, if I may start with the provision of net zero regulated carbon housing. So you would have seen we've introduced that report as part of our appeal submissions, or was rather part of the appeal submissions and part of the clarification to the roof design, for example, with the photovoltaics, is the strategy there. So whereby 40 of the 44 homes proposed are designed to achieve net zero regulated emissions, and the other 4 energy performance certificate rating of A. And where we were at odds with the council, so was in terms of how this related to building regulations, because what I've inferred from the council's response to this is that will be required in any case through Part L of the building regulations. But just wanted to clarify, so it goes far beyond what Part L requires. Is essentially a 100% further reduction on the emission levels set out in a new Part L for those that are net regulated carbon zero, and for the 4 that are energy performance certificate rating of A, it is an 88% improvement on emissions from that, sorry, a reduction in emissions from that in Part L. So obviously, sir, that has environmental benefits, but it also has other social and economic benefits for the future occupants of those dwellings in terms of energy costs to them. And just to clarify, so again, that goes far beyond what a resident might expect to have in terms of reduced cost if the dwellings are simply built to Part L. I guess it's all part of that strategy, sir, of ensuring these are affordable homes and affordable to run.
Okay, thank you.
I don't know, sir, if you wanted me to go through the other benefits now, or if you wanted to invite the council to...
Yeah, I'll give the council an opportunity to respond on that one, because I know there was a lot mentioned with affordable housing before, and it potentially got a little bit confusing trying to deal with all the information. So, Mrs. Hutchinson, if you want to come back on that particular one.
Yes, this is another case where I don't think the appellants have actually read the statement. We do take issue. Obviously, Part L is in place now. But I think the argument was that in 2 years' time, we will have effectively the future home. So you'd be looking towards, it just in 2 years' time, a very, very significant reduction in carbon emissions for all dwellings. So I would have expected this proposal to be future-proofing against that in any case. So it's not a simply Part L disagreement. It's simply that I would expect where you're looking at a development that is particularly for affordable housing, where they have got limited incomes to be able to provide, to pay for electricity, whatever, any fuel, that you would be looking at the most efficient level of homes for them anyway. And that will be a requirement primarily in just 2 years' time when the future homes comes into effect. So that's the only argument that we've advanced. Not that we think, we don't disagree that they should be efficient in this way, but that we would expect them in 2 years' time to be so anyway. And I can't see the benefit of building something at a lower level 1 year, only to find that another year later, if they'd been built then, they would have been at a much higher spec.
Was that all you wanted to say on it?
I'm not going to carry on, sir.
No. I take it you'd like to come back on that.
I'd like to come back, if I may, sir. First of all, there is no evidence from the council that the government, central government, has committed by 2025 to requiring all new homes to be net zero regulated carbon. We are on the beginning of a journey, and we don't yet know when the government is going to require all house builders to build homes to that standard. Secondly, until the council has a local plan, they're not able currently to impose any of these standards on house building in Castle Point. So the fact that you will have here 40 homes which exceed the new building regs by 100%, and 4 of them which exceed by 88%, and these are the regulations that are going to kick in June this year, is a significant benefit. We're not aware of any new properties being built in this borough to this high standard. If you give us permission, sir, I venture to suggest we'll have we'll have the council, I hope, actually being quite proud of this development, because it will be the only one in Castle Point with carbon regulated net zero.
So can I just clarify, if the government was to bring in the legislation regarding future homes, would that overtake what you're proposing if you were to build the houses?
No,
at
they
that
won't
point?
even get to that. No, that's my retort, if you like. No, because the government has not yet told industry when it is that they are going to require new homes to be built to the high standards that we are deploying. Because, to be frank, there is a tug of war between the costs of doing so, say the house builders, versus the benefits, and the government has not yet committed to that. So we're on this journey. This is why you see in the press, sir, sorry, now you got me on my bandwagon. This is why we see in the press, are we going to get it by 2030? So we are way ahead.
But I suppose from my own point of view here, that if it was to come in, would it be better than what you're suggesting now?
No.
And would it replace that?
No, it wouldn't replace that. I would already, we would have, if we get permission and we build out, we are going to be ahead of our time in terms of the building regulations for many years to come. And indeed, the building, we will only have 4 homes, which will have certificate A. The rest will be this carbon regulated net zero. This is innovative stuff as of today, which brings real cost savings, energy savings, and therefore cost savings to the occupiers.
Okay, thank you. Anything further you'd like to add, Mrs. Hutchinson?
No, I think if it was of that benefit, then perhaps it ought to be conditioned. I don't think it is actually conditioned as such, so.
I'll make a note to come back to that. If you need to. Yeah. I thought I might have seen something in there, but I made a note to. Okay, well, we can touch on whether that's fit for purpose at that point then. Okay. You've ticked that box. Did you want to move on to the other benefits that you'd had in your list?
Thank you, sir. I think the next one we had was increase in, the biodiversity net gain, where again there's only a slight difference of view between ourselves and the council, as I understand it, in terms of how much weight should be. I don't think there's any dispute over there would be BNG, there would be biodiversity net gain here through ecological enhancement. It's just what weight should be afforded to that. And I think if I'll summarise, and Mrs. Hutchins can obviously correct me if this is not a correct summary of it, but as I understand it, the council is saying, well, it's BNG is going to come in any case, 10% minimum requirement in the future. But our position is, well, that requirement isn't in now. It's not a requirement to do now. Furthermore, when that requirement is introduced, it won't compel developers to provide that on site. May well just be dealt with through a credit system. And I think the final point we'd make on that, sir, is, of course, paragraph 145 of the MPPF does talk expressly about looking at opportunities for ecological enhancement within the green belt. So this would be ecological enhancement within the green belt. And again, one that wouldn't materialise if this development were not to proceed. think so. The council have said moderate weight. We've said at least moderate weight. So I appreciate it's a judgment call for yourself, sir. But that was one of the
Okay.
points I
So
wanted
you're
to make
saying it
around
could
that.
be anything upwards of that.
Yes.
Okay.
I'll just give you one other reference, sir.
Yes.
Billericay, the Billericay decision, paragraph 42, significant positive weight was given to BNG.
Anything that you'd like to comment on, Mrs. Hutchinson, on that point?
It is down to weight, sir, really. It's your judgment. You can obviously look and see how this compares with Billericay and what they're providing and what we're providing, if that is to be an issue. So,
Thank you. Next.
I think so. We're on to the final benefit of our list. That is the residual economic, social and environmental impacts. I think it's perhaps one we're most surprised about the council stance on. Council suggesting that should be afforded no weight. We suggest at least moderate. And we've already touched upon it, so the importance of construction for employment within the borough specifically. But even just generally, I think it's been well recognised that the provision of development coming forward has indirect or direct and indirect economic benefits, such as additional spending in the local area, demand for services and facilities, so helping support the vitality of communities, additional public open space, for play and recreation. I think it's previous decisions, and we've given you one example there of Burley and Wharfdale, which is I-10 core documents, make it clear that is an additional benefit on top of simply the social benefits of providing housing. So I think our position would be it would be inconsistent with decisions such as that to suggest it is not an additional separate benefit. So I don't believe that's a particularly controversial stance to take either, I suggest.
Okay. Mrs. Hutchinson, anything you'd like to add on that point and the reasons why the council have taken the view that it has on this particular one?
I think so. I don't dispute the fact that they have benefits. I don't think that is the issue here. I think it's the fact that I don't consider they are very special circumstances and are of such weight to provide very special circumstances. If I've said it at paragraph 6.53 through to 6.56. That's where I sum up what benefits the appellant has put forward and how I view them. So I'm not disputing that they are benefits. They're always benefits of any housing development. It's whether they tip it into the very special circumstances that I think is the dispute, which is what I've said at the end of paragraph 6.56.
Okay. Thank you. Anything else you'd
I think
like
so,
to add?
just to say so, I think on that basis, there's no good reason not to apply the approach consistently as your colleagues have done in terms of the weight to be that this should be afforded weight. We don't contend that this alone would constitute very special circumstances, but it is clearly a benefit that must be considered in the planning balance. And I appreciate, sir, the degree of weight to be afforded to it is a matter for the decision maker, but I think there must be at least some weight, logically.
I made a note throughout my notes on screen here about referring back to appeal decisions and what have you. And if there's any that you want to specifically draw upon that you haven't already raised, and I think I meant to do this with Greenbelt, for example, as well. If there are any, you may well have brought my attention to them since that main issue. But if there's any that you feel are specifically pertinent to this main issue, or any that we've gone through already, then it might be an opportunity to do that, and potentially the reasons why they might be relevant to the circumstances before me for this appeal.
I believe, sir, I'm looking around the college as well, that all of the appeals we have referenced have been where your colleagues are to grapple with very special circumstances, and thus, they're relevant in that respect, in that they give us an indication of what should be afforded weight, potentially how much, in similar circumstances to this. So I don't think there's anything else we need to add to without simply repeating what's already in our written submissions.
Okay. That's fine. Yeah, that's okay. Good. Does the council have any comments on any of those appeal decisions? I think some have come obviously since the initial evidence was compiled. So if there's any you want to refer back to that we haven't already touched upon.
Only briefly saying that obviously, I mean, we are dealing with some of those that are sort of huge developments that are bringing other benefits as well, rather than just, I'm not going to belittle the fact that it's just 44 affordable houses, but that is what we're dealing with here, whereas they're dealing with 200 or whatever houses on different sites, so they bring other attendant and quite significant benefits in other ways. So I don't think there is a like for like. In terms of the one that is pertinent, I think, to Castle Point, which is obviously the Road North, then that site is a totally different site as well, in terms that it was considered to be a rounding off, and it had a clear boundary that would, if you took development beyond that, it would clearly breach into open green belt. So that was the sort of the only comments that I would want to make, because I could probably, if I thought about it, I could probably brought a load of other appeal decisions that went entirely a different way, different judgments. So I don't believe in it, I'm afraid, unless there is something particularly relevant.
Okay, thank you. Okay. Anything finally on this main issue?
I just wanted to come back and remind you, sir, that Maitland Lodge, which we've already referred you to for in the context of affordable housing, is just a 47. It's that I accept you've got some appeal decisions dealing with more substantial numbers of homes, but equally you've got some which are rather more on all fours with us.
Thank you, sir. I just wanted to flag the one appeal decision I believe the council has introduced, which was to support its case, which was the 301 Rayleigh Road, and limited weight to be attributed to affordable housing. There may be benefit in turning that decision up, so it's appendix to the Senate Common. Or, I'm just going to quote one paragraph if you're happy for me to do so. They're talking about the need for affordable housing. Paragraph 31, talking about the need for affordable housing. The inspector then goes on to conclude, however, there is no legal agreement or unilateral undertaking submitted with the appeal that would secure this benefit as part of the current proposal. And this is not a matter that could satisfactorily, I think I'm supposed to say, be addressed through the imposition of a condition. For that reason, I think that's really key wording there, I only give limited weight to this particular benefit of the scheme. So acknowledging it's a benefit, but only giving it limited weight, because unlike in this instance, there was no mechanism to secure that benefit.
You recall, sir, I did say I disagreed with that.
Okay. I'm happy to move on. If everyone else is, you need to add anything more? No? Anything from anyone up there? Yeah.
Can I just make an observation about biodiversity net gain, whether it's a benefit or not on this site? It's just a point, I suppose, and you could probably get experts here around the table batting it back and forth. But I think to most members of the public, even people that have looked into this, researched it and studied it, struggle to see how you could have an area of, say, meadow, perhaps a few trees, this, that and the other, green belt, and then you concrete over it with roads and housing, put a hedge in and call that biodiversity net gain. So, and I would definitely dispute that some are saying, not only I dispute that that is a real net gain in biodiversity, but also I would dispute that if this housing doesn't go ahead, you can say concretely that there will never be any biodiversity net gain on that site. You know, without a crystal ball, who knows? Someone might go and plant some trees on there or anything. So you can't sort of say the biodiversity net gain all hinges on this concreting over of that green belt. Thank you.
I mean, we've spent very little time, sir. This is not a criticism, it's just a fact. We spent very little time actually looking at the scheme, looking at the landscape. All of these things have been designed specifically to enhance the biodiversity net gain. And you'll see on your site visit that it is not a particularly rich site, I suggest, save for the edges, as it were, which are retained. So, I mean, these things are matters of fact.
Thank you. Would you like to add anything more? No. Okay.
So can I just speak? I mean, the council is irrelevant. The council is to obey us. We are the people of Council Point, and we don't want it. I mean, they must understand about that. I mean, they're coming here with this property. They're not giving it to the council. Someone's going to make a profit out of it. We don't want it. We want to be left alone. 64 years I've been in this community. I've seen Hacks Farm arrive. I've seen Wiggins arrive. I've seen the Rundles that have built up. And it's got to the point it's saturated. And I can't see why we're arguing. We just don't want it. I'm sorry.
Okay, thank you, sir. I've noted what you've said. Anything else from anybody? No? We had on the agenda a section for other matters. I think we've covered most things now, but if there is anything else that anybody wants to raise at this point, then I'm happy to go through it. The only thing I wanted to do myself in this section was just to provide an update, which you may already have seen, which is that I have consulted Natural England about the habitat regulations assessment that would be required as part of the appeal were it to be allowed. So that's underway, and any response that's received from Natural England will be circulated in due course.
If I just clarify certain things, it's normal practice, I think, in sort of most of the Essex authorities that are governed by the RAMs and things, that they don't consult Natural England with schemes of under 50, which is why they wouldn't have been. So when the RAMs was prepared, it was prepared in consultation with Natural England, and I think there's this general agreement amongst Essex authorities that that's how it's dealt with.
I can appreciate that, yeah. And I understand why Natural England would probably advise that as well, because it's a lot of work for them to deal with. But in cases of appeals, as a competent authority, we have to do it. So yeah, that's underway, and there are some generally standardised questions about the process and whether they're happy that the mitigation that's proposed through RAMS is sufficient for the scheme. So Okay, thank you. So I don't have any other points that I want to raise in other matters, so I'm happy to move to discuss planning conditions, if that's okay. Obviously, I circulated quite a lot of comments prior to the hearing, which you've worked together on to produce a revised set of conditions. Some have gone away, so I think it would be helpful because it wasn't explained in the actual documentation that I got why conditions were deleted, for example. There were a number that I raised questions on as to whether they were capable of meeting the tests that are required for planning conditions. And it was a bit of a sifting exercise for me to try and work out what had actually happened with conditions and why. So it'd be useful potentially initially just to explain why some of the conditions that have gone. I think one in particular related to the highway access and potential future liability for damage caused to the highway by construction traffic. And that was raised by somebody in the audience this morning as to who would be responsible for that in the future. So it'd be interesting to understand the reasoning why it went based on what I'd asked. If you'll just bear with me, I'll bring up my pre-hearing note and we can potentially go through. So it was condition number 3 on the original list of conditions that was provided. And I'd raised how one would be expected to be able to evidence that damage or defects have been caused to the highway by construction traffic, and how that would meet the tests required in the NPPF regarding conditions. There are a number of other conditions where I made comments. So it'd just be useful to explain what process you went through on the conditions if you could. So I don't mind who does that.
I knew you'd be looking at me. I'm just trying to get back to where if I remember rightly, the appellant said there is no policy governing it, which I fully accepted. But also, it is actually, there is a highway condition survey contained within the Construction Environmental Management Plan. So there is a requirement there for paragraph 3.9.1, prior to commencement of any construction works on site, suitable highways condition survey report of construction traffic from the A127 should be undertaken. It includes full photographic evidence, etc. And then a further survey to be undertaken post-construction to identify any detrimental impacts, and any identified damage or further defects would be mitigated or improved to the standard identified at pre-construction stage. So it was agreed that it was
another condition.
Yes, it
right.
was
Okay.
within that the SEM.
Okay.
You didn't get our annotated.
No, I didn't.
No. If you'd had that, you probably would have seen all the different comments that were floating around
Yes.
between us. So
For future reference, that would have been very helpful. Because I was sat for about an hour the other day trying to work out, firstly, the order, because some conditions had moved, but then what had happened with conditions as well. So yeah, if there's any others that you want to go through, just to explain to me then what's happened, and then we'll look at any remaining points that I might have. No, happy to have in this instance. Well, conditions are often dealt with in a roundtable discussion, aren't they? So, yeah, I'm happy for you to do so.
Okay. I've got the ones, sir, that were changed, I think, in the way that they were in the original format. So if you want me to go through that, I might be able to just sort of explain to you where the changes have taken place.
Yeah, okay, let's do that.
If that's helpful. I'm looking at the version of the 20th of March. Have you got that?
There was a 21st of March one that was the one that was submitted to.
Yes, and I think the one before that had all the changes that we then
yes,
sort of...
so that makes sense.
I pruned out the ones that were agreed.
Yeah.
Yes, so condition 3, as it was, which was the commencement of, prior to commencement, the construction works on site, so the condition survey, that was deleted. And then there was a bit of tweaking to the condition of what was condition 4, to take out excavation of the site. And then condition 5, we tried to tie it a little bit more accurately, referring to a plan, etc., so that it was quite clear as to what the condition related to in terms of the FRA and the SUDS as well. So that included for the construction stage, which I think had been a separate condition. So we tried to tie that in with that. So at the end, in the sort of all the Roman numerals, there was another one put in, i.e. timetable for implementation. So that sort of tried to delete another condition. And then I'm sorry, sir, but I'm going to get myself muddled up on this as well. Yes, so there was a management and maintenance plan for SUDS. Was sort of, we played around with those to try and limit how many conditions there needed to be, so that they covered all the requirements. And that included the log as well, I think, yes. So a yearly log was amalgamated into that condition. We then had few other changes, a little bit of tweaking in some of the ones, but condition 9 was changed so that that was so that the roads within the development were able to accommodate and the weight and turning manoeuvres of a 32-ton refuse lorry, and then an implementation added to that as well. So 10 got deleted because it had been put somewhere else or been combined.
Yes, that got moved up, didn't it? So it was more logical. So it was next under
yes,
the
so that it tied in with the other ones.
Condition.
And I know they're not quite in the strict order they ought to be in terms of pre-commencement and things like that, but I did try that and it just threw the whole lot out of...
No, I sometimes find that leads people to be confused further down the line.
Yeah. Right, here's condition 10 that, yes, we were referring to earlier on. So this is... this requires a report by an independent certified standard assessment procedure, SAP, for the net zero carbon strategy report. So it ties it to the net zero carbon strategy report that was submitted.
Can we just pause there for a second?
Yeah.
Because I want to make it absolutely clear that, you know, we are committed and we are expecting a condition to tie us to 40 net zero regulated carbon dwellings and 4 with the minimum performance energy certificate rating of A. But one of the things we don't wish to be tied to is how we get there, if I can put it like that. So in the net zero carbon strategy report, there are some tables which indicate how one could get there. And we don't wish, whilst we wish to be tied to the end result, we don't wish to be tied to those tables. I suspect that, so that's one of the reasons why we were a bit concerned about the wording of condition 10, and we thought one answer to that might be to stick in the word broadly. The council didn't like that, which I understand. I'm wondering, therefore, whether something which would be more specific would be better. So something which said the developer will submit a report from an independent certified SAP assessor, forgive the terminology, which confirms that 40 dwellings have been constructed to achieve net zero regulated carbon, and 4 have been constructed to achieve a certificate A rating, is more precise. You then know that you can attach weight to that. We know what we have to do, but how we get there is left to us, because this is a fast changing area, and there may be products and ways of getting there which were not known at the time that the net zero report was written. So I'm sorry to...
I think it is more precise, because at the moment this is potentially suggesting that all dwellings have to be net zero. And
Well,
if that's not something that you're offering, then
no, I'm offering 40. Yeah.
yes.
Yeah.
So then that doesn't meet the requirements
Exactly,
of the scheme. So it's not fit for purpose in that respect. So I think yes, that's something that you can go away and look at and provide an updated version on to me in due course.
No, I haven't got a problem with that. I mean,
Okay, super.
I
We'll
think
do
it was
that.
just assumed that if you complied with the net zero carbon strategy, I thought that said that 40 would be and 4 wouldn't be. But
It does say 40 and
Yes,
4,
so-
but it introduces, if you like, other potential issues, because there is other detail in there that I don't wish to be tied to
Yeah.
for the reasons I've given. So if you're happy, sir,
Yes.
we can, outside of this hearing, submit through the case officer a revised version of condition 10.
Yes, that's fine. I think a general layperson reading that condition is the way that I suggested it just then, that they would assume that all dwellings are going to be net
Yes.
zero.
Yes,
They might not necessarily read the document.
I agree.
So yeah, I think it would be
Yeah,
more
more than
precise
happy,
to
yeah.
refer to the specific dwelling numbers on each type of improved efficiency. Am I right in thinking that the other changes that you've made to conditions beyond that point are they relatively minor? And I think the numbering stayed fairly consistent after that point.
Yes, I
mean-
think so. I think I just sort of quickly scroll through. There's a few tweaks. I think a lot of it is probably implementation, tying it to particular plans, etc. So just making them more precise.
Yeah.
I don't think there was anything fundamental other than we took out prior to occupation of the 44th dwelling, private amenity areas to be made available, etc. So because those were contained within Section 106. So there's that management of the open space that was removed. So those conditions were taken out because of that
Okay.
reason. And then I think the only other one that was perhaps changed has been the sort of the noise one, which I think when I sent through the conditions to the inspectorate, I said there was still an issue potentially about the condition 26, I think it was. But that has been agreed between the parties. So that related simply to a scheme detailing that it was in accordance with the BS in terms of acoustic.
So that one's now agreed, is it?
Yes,
Right.
yes.
Okay.
Sorry, Ursula, I think the only other... Yeah, you're right. It was generally either they were covered already by the 106, or it was tying up things a bit more tightly. But I suppose the other one to flag would be the making sure that the fencing was was hedgehog
Oh, yes,
friendly.
hedgehog friendly
Yeah.
and badger friendly.
Badger
Yes.
friendly.
Yes. There are a few questions that I've got on the revised conditions. So if we wanted to make sure we've got those in front of us now, just to be 100% clear. So the first one relates to the cross-referencing effectively that might occur between conditions 6 and 13. So the details in condition 6, I'm just wondering if they're already dealt with in the CMP. That's the one dated December 2021.
No,
And
they
therefore
weren't.
controlled by condition 13.
No,
They're
they
not.
weren't. That's why I left that one in. I think I did put a note in saying, and it was agreed between us that actually it wasn't covered.
Right, okay. And they're not covered. Are they covered in the flood risk assessment as well?
I don't think it does construction as such. It deals very much with the development once it's built and constructed. So
Okay.
very rarely do I see this condition always comes up, and it's usually put in a condition with the SEMP, but for some reason, I think it was Castle Point wanted this to be slightly separate.
Okay, thank you. Condition 15, I raised a question about the visibility displays and whether they could be achieved on highway land. It's just confirmation as to whether that's actually the case. Is that a yes?
Yes, sorry, sir. Yes, that is the case. That's
Or our land.
or exactly, yeah. So land under the appellant's control. That's the key point there. I think that's an addition there in the third line to tie it to the AMA drawing as well, just to clarify that.
Okay. Condition 24, this point just touched on. It's as to whether that's already potentially dealt with in the open space management plan required through the section 106.
The one, as I remember, the 106 deals with management in terms of open space and how it's looked after. But this is a slightly different one because this is looking at the ecological side of things, and I don't think it's covered by the section 106 in the same way, which is why we left this condition in.
Okay. Condition 25, I'd said that I wondered if this condition was a bit overly restrictive, in terms of the properties that may need to have obscure glazing. There might be some that are side windows on a corner and doesn't lead to overlooking of anybody, for example, not facing another window, so you're not going to have direct loss of privacy. So it's just whether you could be more precise in that respect as to which plots specifically need to have that restriction in place.
So
We did tweak this one as well because the way it's now written is the windows shown in a side elevation at first floor. So it's the windows that are actually being shown to have obscure glazing, and then it sets what the standard to that obscure glazing shall be.
Right, so they've already got the right. Okay, they've got
yes,
obscure glazing
it was
on.
a wording. I think with the original one, it wasn't appreciate. It could be read differently to what was intended. So yes, Ms. Hutchinson's correct.
I
There
see.
are
I see.
It says just obscure across specific windows in certain elevations, and that condition is simply ensuring that ones we have shown to be obscure glazing will be obscure glazed and will be retained as such.
I think we've taken out the height requirement as well for the windows, which was in the original one, so that it simply refers to the windows that are being shown.
That are already shown, yes. Okay. They're the only ones that I had questions on. Happy now with the wording of everything else. So if you wanted to work on Was it 10? Did you say? Yeah. Work on 10 and update the list accordingly. Clarifying that you agree to any pre-commencement conditions as well. That would be helpful. Okay. Anything else? No? Happy? Okay, so the planning obligation. Few things. I'll just open that first then. So the first point was clause 14. Refers to SIL charging. Are there likely to be any immediate implications for the agreement due to the proposed SIL charging schedule?
Yes, sir. I've just been advised that, and I had it up on my screen. The draft charging schedule has been agreed and was published on the 23rd of March 2023 and is to be effective from the 1st of May 2023. I've only just got this, so I can forward it through. Have you got a copy?
We're aware of this. We're aware of the decision of the council, but I don't think that's quite the question you were asking, if I've understood you correct.
No, that was right. It's as to whether it would basically make elements within the 106 null and void, not required because they're dealt with through SIL charging. Effectively,
it's all about the yes. So if a decision comes after the 1st of May, the 106 provisions on the face of it fall away insofar as those provisions relate to infrastructure, which is covered by SIL.
Okay. It might be helpful then if there's some kind of agreed position as to where we would arrive at with any affected elements of the 106 if a decision was to be, for one reason or another, delayed until that point, and it was to allow the scheme. So it might be helpful if that is provided, just so I know which elements could be affected by the SIL charging effectively.
I can help you with that now, if I may. So one thing that will not be affected is RAMs. So the RAMs payments are not covered by SIL. They are dealt with separately because those are monies that ultimately go to the county for the county to expend in mitigation of the additional recreational pressure that the housing will cause. So far as the other elements of the 106 obligation are concerned, sir, can I just first of all say that as between ourselves and the district council, there are no issues as to SIL compliance, Reg 122 compliance with the various contributions. So that is to say, you've got contributions in relation to healthcare, indoor sports, the mugger, so that's other play space. You've also got contributions to the county in terms of the library and the residential travel pack, and there are no SIL issues in relation to that. I do have a SIL issue to raise so far as the county obligation is concerned for primary school provision. And the county have been put on notice of this, but we have not found, we have not managed to elicit any sort of response from the county on this point. But the point is related, sir, to the SIL examination. So bear with me for a moment. So the council were planning to advance a SIL levy when in alongside their local plan, the now withdrawn local plan. So when that local plan was withdrawn, the infrastructure that was being costed necessarily changed, because the council could not rely upon the development in the withdrawn local plan, but they wished to continue with SIL. So a number of homes that was the subject of the infrastructure levy came down. But as you will see from the examiner's report, one of the things that was agreed in the context of the examination was that there was no need for SIL to be levied in relation to education costs. And that was because the county's evidence was there were adequate school places for some 1,200 odd primary, for some 1,200 homes. And so the inspector, so that item was not included in Castle Point's schedule charging. So all I'm really saying today is, if there is no need for primary school contributions for 1,200 odd homes, why is there any need for me to pay primary school contributions in relation to these 44 units? And we have, as I say, alerted the county council at this point and got no response to them. Now, in a way, that problem, you might think, goes away in a SIL world, because we're governed by SIL in a SIL world, and the SIL isn't seeking to collect any contributions in relation to education. So, I mean, for the purposes of the 106, there are no drafting changes that need to be made as such, because in there, the person or the parties drafting have included a blue pencil clause in the 106, which effectively means, in a world where you say a contribution has not been demonstrated to be necessary and therefore fails SIL Reg 122, the obligation to pay for it falls away. That is clause 8.13 on page 17, sir. That's where the blue pencil test clause is to be found.
Can I just clarify whether the evidence that you've referred to about the county council not requesting that primary education falls into SIL is in the information that I was provided with?
Yes.
I'm just trying to find where I've saved that, just to look at it again.
Yeah.
It's G4, sir. The core documents is the report on the examination of the council's SIL charging schedule, and
that doesn't help me because I've saved things differently to the core
right.
documents, because I'd already extrapolated everything before the core documents list came around, so I didn't duplicate everything. So Just bear with me 1 second. I found it. So the SIL examiner's report is that what
Yes.
we're referring to.
Yes, paragraph 12.
Okay, that with what that says in the examiner's report, Mrs. Hutchinson, do you have any comments about the inclusion then of the primary education request in the section 106?
I think, as far as I can see, sir, I mean, that is a general. The examiner's report is obviously relating to the whole of Castle Point, and I think that the consultation response is obviously more local, and that's the only thing I can think of that within a sort of a borough, you will have areas where there is scope for sort of, there's capacity, and there will be other ones where there isn't. And all I can assume is that this consultation response was designed to address that, but I cannot say anything further than that, and I don't know the details, so sorry. I apologise, I can't help you any further.
Anything in response?
I don't think so, sir, other than to say, you asked a question earlier about what is covered, as I understood it, what is covered by SIL, as it were, and you can see that healthcare facilities, libraries, green infrastructure and open space sports facilities, you can see all of that is covered in the Brave New World with SIL contributions, or sorry, the SIL levy. And the drafting in the the clause in clause 14 in the 106 is seeking to deal with that, when it says, if at the date of planning permission the council has adopted SIL, any contribution payable which is for infrastructure which is within the same class, so let's take library contributions, because they're plainly covered by SIL, we wouldn't be paying under the 106.
Okay.
Sorry for this added complication.
No. I was wholly ready for this because I'd read that clause, and I was satisfied that there were provisions in place to cover matters. But it was helpful for me to go through, because things have changed and the implication for education specifically, to just cover that and be clear on where we're at with that particular point. I think my only point about drafting was paragraph 1.1 of Schedule 4. Let me get to that again as well. I was of mind that it might be worthwhile inserting the word only on the final line.
To only pedestrian cycle.
Yes. Because that was something that was raised earlier.
Yes.
And it was to be a question of, as mine as to
Yeah,
whether that would then nip
Yep.
in the bud any concerns that people
Yep.
might have about access being formed. Is that a problem? Would that be a problem for the council?
I'd have to take instructions. I don't see why, but I can't say one way or the other. So
Okay. Well, if you want to discuss that between yourselves, because obviously I need a signed copy of the Section 106 in any case, and I don't have that as things stand.
Indeed not, because we wanted you to have the
Exactly.
opportunity of casting your eye over it and
Yes.
correcting our drafting. Thank you very much. I mean, that's what it's intended to say. So I appreciate Mrs. Hutchinson's in a difficult position right now because she hasn't got the people who are doing the drafting sitting right by her. But can we sort that out, as it were? Again,
Yes, alongside the condition 10 as well, and provide both and a
yes,
finalised copy.
yes, and you will obviously want an executed
Yes.
version of that. And so, might I just gently raise that issue with you now? Is now a convenient moment to just mention that I have a landowner signature to obtain, then I need L&G's signature, then I need it to go to the county and then to the district. There's only one day in each week when the two authorities sign such documents. So,
Okay. What time frame are you suggesting, basically?
well, I have in mind your time frame for Natural England, and the you wanted Natural England to respond by the 24th. So if it didn't seem too cheeky, sir, my opening gambit was, what if I stick to the 24th? So you've got the same deadlines.
Yes, that seems perfectly reasonable.
Thank you very much. Thank you.
Yeah, should give you sufficient time, hopefully.
Yeah. Yes, thank you.
The one final question was, when would the open space be provided? Because there doesn't seem to be a reference in there as to the delivery date, unless I'm missing it.
Just
Because we had the planning condition before, which said about the 44th dwelling, I think, but it's not transposed over into the language in the legal agreement. If I remember rightly.
transfer. I mean, it's covering the management of it, not the. As I'm sitting here, I'm thinking that where's the trigger, which is what you're looking for.
Yes. It's a reasonable time frame, and I think depending on the phasing and delivery of the properties, it might well be that it needs to be provided at an earlier stage so that it's there for some occupants to use whilst other properties are being built. So at the end of the development might not be sufficient. I'm not sure where the nearest open space is to the site, but it may well be that it's not close. So I think it would be reasonable and proportionate for it to be provided. Probably around half dwellings completed.
Yeah. Can we just have a little We're just thinking about the practicalities of the build out, and I think halfway ought to be fine. So effectively, is that another task for us to agree a planning condition, which effectively is the trigger for the open space and says something along the lines of no more than half the dwellings.
It might well be easier to do that than trying to tie it in with the 106.
Yes, exactly.
We just put the condition back again and change the number effectively, but we'll check and make sure it's fit for purpose. I've just had a quick confirmation that changing the word only to include only should not cause a problem. So.
Okay. So you'll still tie everything up just to make sure everything tallies across with the conditions in the 106 by the 24th. I think that's probably wise to do that, if not before then. If there's
As far as I'm concerned, the conditions will need to be done next week because I'm not going to be in the country after that. So.
Okay. Well,
Lucky
you.
lady.
Lucky you.
So-
yeah, that's fine. If he works the timetable, you can between yourselves and get it back to me as soon as possible and execute the 106 as soon as you can after that.
Yes. I mean, if it comes obviously sooner than the 24th, you'll get it as soon as it's ready.
Okay, great. I don't have any more questions on that specific section, so we can move on beyond planning conditions and obligations to costs. Are there any applications for costs?
No,
Okay. No. Okay. Music to an inspector's ears. So that just moves me on to the site visit. As I mentioned before, I've already undertaken my pre-hearing site visit around the site, so I don't feel I necessarily need to look at those other locations again, so it would be restricted to the actual site itself. I'm happy to do that on a access required basis, so allow me access in and I can wander around to save everyone travelling to the site, but it would just then be to arrange that access.
So we're happy with that. We just want to give you one little warning, which is we'll have to give you a number, a security number, and I'm told it's a bit fiddly. So if you're happy to sort of do that on your own, as it were, you could let yourself in and let yourself out. That is one option, or else somebody goes with you just to make sure that you can get in. I imagine getting out is going to be a lot easier. I'm guessing.
Yeah, I think from a security point of view of the site, I would much rather someone else be responsible for making sure the gate is closed properly, and I'm not held responsible for
that's understood.
Any future break-ins, for example. That would not be.
So that's understood.
From an inspector's point of view.
Would you like someone, as it were, to be the gatekeeper, because it literally is a gate? Are we able to do that without burdening the council, or do you need two gatekeepers?
No, not. I don't feel the need to. If it's just someone opening a gate
neither do
for
I.
me,
I'm
then
just articulating this so that it's all out in the open.
I'm more than happy if it's simply somebody keys in the numbers, you go through, come out, and no words are being exchanged on anything of the case. Then more than happy if that's it.
Okay. Yes. Let's do that.
Fine.
Excellent. Okay. When do we think would be appropriate time? I think it's only about 10 minutes from here. Traffic willing, I appreciate from local residents, but so if we, who would be coming? Hello.
Gilbert at the back there will be the lady who will open the gate.
Okay.
Do you have a car? Yeah. So she's here with a car.
Okay. Great. Well, I'll probably head home afterwards, so I'll go in my car as well to the site. Is there room for 2 cars on the front of the site? Okay. Okay then. So you'll probably get there before me, so I'll see you at the site in due course then. Excellent. Thank you. So, anything else from anybody? Any documents to hand up or anything at this stage? No. Okay. Well, if everyone's happy, then I'll close the hearing then. Yes. Excellent. Thank you everybody for your time and contributions, including those that have stayed with us until the end. Thank you for your contributions, and I wish you all well. Thank you.